the way forward for constitutional reform. My position was very clear when the proposal came that we should enact the Constitutional Review Commission Act with the view to establish a Constitutional Review Commission charged with the responsibility of reviewing the 1997 Constitution and take into consideration fundamental principles that will form the basis of the Constitution of a third republic. I will have a more comprehensive presentation, but with this brief presentation, it is important for all to recognize that from Chapter 1 of the 1997 Constitution, which states very clearly that Gambia is a sovereign republic and sovereignty resides in the people of the Gambia, from whom all organs of government must derive their authority, and to whom they will owe allegiance, and for whom they will ensure that authority is exercised to serve their general well-being. That is there in the 1997 Constitution. The sovereignty of the Republic and the sovereignty of the people. So the Constitutional Review Commission had to be charged with that responsibility. Any new constitution must be embedded with such a principle. But my contention, before I go on with the principle, from the very beginning, was the issue of how. Not what ought to be done, but how we were to do it. The 1997 Constitution was not overthrown. It was a living document. To change it, you have to rely on its provisions. And the only provision that existed for its changing was Section 226. We talked about the alteration of the Constitution. And there it gave us two provisions. Provision from 1 to 3, 226, 1 to 3, where if we want to carry out amendment, it was restricted to amendment of those provisions that were not entrenched. For those provisions, we can publish in the Gazette what we intend to amend in the form of a bill for a period of 3 months and another publication for not less than 10 days before introduction in the National Assembly. Once introduced, the National Assembly will have the first reading, but at the second reading, where we debate the merits, and the third reading, where we debate the details, we will have to have 3/4 majority of National Assembly members before it passes its stage, and then it moves into the third reading as the Constitution that is passed. And once we pass it at the third reading, then it goes to the President. And the President will assent to it, and that will become law. That is what happened when the National Assembly changed the 65 years. You saw the error that was made before, that this was not published in the Gazette for the specified time, but laid at the National Assembly at a time when the APRC constituted the majority. I think you remember what I wrote at that time, and showed that that process was unconstitutional. And I'm glad that the substantive Attorney General, when he came, because he had been appointed, but he was outside, when he came, he agreed, and therefore that was withdrawn ultimately, and the views that abided by the time frame submitted to the National Assembly eventually passed and sent to the President for assent, and that constitutional provision was changed. So we are not talking about theory. We're talking about practice. The provisions that were not entrenched had been changed in this phase of our National Assembly. And therefore, the proposal was, since we have provisions that could be changed by the National Assembly members, then we should look at all those provisions and prepare an agenda for their change. But if you go to subsection 4, link it to subsection 7. Subsection 7 indicates all the entering clauses. And subsection 4 indicates that if you want to change those entering clauses, you have to go through the same process of publication for not less than 3 months, second publication of not less than 10 days, accepted, supported by the National Assembly, also by 3/4 majority in the second and third reading. But with that, we do not pass it to the President for his assent. No. We simply give it to the Speaker will give it to the Independent Electoral Commission, and within 6 months the Independent Electoral Commission will then have a referendum. Once it goes through the process of a referendum, then of course that is approved, and automatically the National Assembly will pass it to the President, and the President must assent to it within 7 days. That is the law, and therefore that's how we can change both the provisions that are amended, that are entrenched, and those that are not entrenched. That is what I emphasize then. That yes, under the Constitution, if you look at subsection 9, it talks about alteration, that it means the amendments or reenactment of the constitutional provision, the issue of repealing it, the issue of changing any of it, any form of modification. Yes, alteration means all that. But then, if it says you can repeal something, but how do you repeal? If it says that you can promulgate, where does it say that? Wholesale, promulgation wholesale, repeal wholesale. Where does it say it in section 226? That was the issue I raised then. And therefore, we ran into a problem when the Constitutional Review Commission did its work by virtue of the fact that the National Assembly chose not to take that route of amending wholesale what we could amend, and taking to a referendum wholesale what could only be amended through a referendum. They took the route of establishing a Constitutional Review Commission to review the Constitution, maintain some of the principles, the whole concept of ensuring the sovereignty of the people, the sovereignty of the Republic, the supremacy of the Constitution, moving separation of powers. All these were principles that they were supposed to rely on. The secularity of the state, having the democratic system, where government that owe its powers from the authority of the people. All these were listed down, and they were asked to go and draft a new constitution, and after the draft submitted to the President, would have to do nothing to touch it, and then they will publish it in the Gazette, and that publication will be followed by publication in any other domain. That is the task that we gave the Constitutional Review Commission. They had consulted, they drafted the Constitution, they submitted it to the President, published it in the Gazette, published it in other domains, and the nation continued to review what was published. Then the D-Day came, when the executive started the process of preparing a bill, submit it for publication for more than 3 months, second publication for more than 10 days, and then submission to the National Assembly for action. They brought the bill, and the draft constitution was part of the schedule. And the bill sought to promulgate a new constitution, and by virtue of that promulgation also to repeal the 1997 constitution. How were we to do this was the question hanging over the National Assembly, and we'll look at that. But as the National Assembly members looked at the principles of the bill, why? Because the Constitution states very clearly that we cannot consider any bill unless it is presented to the National Assembly with an explanatory memorandum indicating the defects that it sought to address and the necessity for introducing it, so that the purpose and objects of the bill will be understood before we go into the detail. The CRC had done the work of not only presenting a draft constitution, but they presented their report. They also presented their explanatory memorandum, so that made it easier for the National Assembly members to be able to see exactly what the objects and reasons were. Under our Standing Order 64, the same requirement exists, that they must explain all the consultation, all the steps they had taken before coming up with the bill. So the debate then, after the first reading, was centered on the objects and merits. But as you can see, even that debate was intruded in a way by looking at the details. And some of the details would be considered by me, clause by clause, in the presentation that I will ultimately make for consideration of all Gambians, because the debate must now be shifted from the National Assembly to the public domain. This is a matter of the people, not just a matter of a selected few. The task now is to go back to the people and then explain to them what is there, for them to choose, for them to determine whether those who raised their hands in support of it were actually serving the interests of the nation, or those who oppose it were serving the interests of the nation. It's for the people to determine. Recently, I even heard somebody who is a preacher indicating that the provision which dealt with something that could bring about same-sex marriage. And some National Assembly members even raised that issue. And you look at section 27 of the Constitution, you can see what it states, that men and women of full age and capacity have a right to marry based on free consent. That is there in the 1997 Constitution. That is still the Constitution of this land. Nobody had ever had a summon against that provision. And since the provision exists, nobody had ever talked about same-sex marriage. Yet it is there, men and women, section 27. In my comprehensive analysis of the details, I will read it for people to hear it themselves. And if you look at the draft constitution, in fact, it has simplified it so that it will be incapable of misinterpretation. It says a man and a woman of full incapacity have a right to be married. And then it goes, such marriage, specifically mentioned. The fourth aspect is the indefinite article, a man and a woman, so that it will not be man and woman. In general, it's a man and a woman. So you are talking about two entities. Indefinite article, a man and a woman. And then he said such marriage. Which marriage is he talking about? No. And then it used the. That marriage, the marriage, must be based on that concept. So the definite article. So you look at it, the grammatical and ordinary meaning is very clear to anybody who wishes to be honest. Yet some National Assembly were questioning that particular provision. And some people are preaching about it. And then, how can we build a nation? Where lies the intellectual honesty and intellectual maturity? That what is properly constructed, incapable of distortion, is now being distorted up to the level of the National Assembly. Questions were raised. So we must take this to the theater of the people, clause by clause, so that all the distortions that they are put in the minds of the people will be clarified. There are things that are weak in the Constitution, things that need to be improved on. And that was the discussion. Could we touch it? Couldn't we touch it? These are all debates that we should carry at the preliminary phase of the constitutional review process. But essentially, this is the problem that we have had. And what people fail to realize is that if you do not have the 2020 draft constitution eventually moving to the level of promulgation stage, we are left with 1997.
Yeah, Honorable, I just want to break you here before we go, because others are watching and they just pose a question and it reads, but man and a woman have the right at the right age to get married. To who? If you say that, it has separated, then who are they talking here?
He's saying such marriage. Yeah. That is the marriage of the man and the woman. Read that again. He says such marriage, meaning the marriage of the man and the woman. The two are pairs. It is talking about a man and a woman. These are pairs. And the such marriage is the pairs. The marriage of the pairs must be based on consent. Free consent of the two. Look at thee. You will see thee, the definite article. Such is there, thee is there. So from the indefinite article, a man and woman, it goes such marriage and the marriage. What is that talking about? Definite. That's not capable of misinterpretation. Not only that, under Gambian law, you must marry based on the constitution. There must be act of the National Assembly that shows how marriage should take place. You will see the Christians have their marriage act, the Muslims have their marriage act, the state has its marriage act. And you will not see in those marriage acts anything that talk about same sex. So on which act are you going to rely on to have same-sex marriage? I hope the person who has posed that question will pose another question to deal with what I've said. I am saying these are distortions aimed at misleading the nation and misleading the people. And clearly, whether in religion, whether in academia, if you cannot read, you should not engage in a debate.
Thank you for the clarification.
If you cannot interpret, don't engage. If you cannot comprehend, don't engage in it. They know nothing about it. So therefore, knowledge is a reality. And any nation that negates that knowledge is doomed. And that's where Gambia is heading. Because people are there who are not willing to debate, because the issue is to debate. Nobody is saying they have absolute monopoly of knowledge. So in short then, in that National Assembly, people were dealing, for example, impeachment of a president. If you go to the 1997 Constitution, that 50% they were talking about is what is in the 1997 Constitution. So you abandon the 2020 and you go back to the same provision which exists in your 1997 Constitution. Wait until I deal with it comprehensively. You will see that the comments that people made had no basis, because it's either something that is distorted or it's something that is in the 1997, like citizenship. What is citizenship in the 2020 is exactly what is in the 1997 Constitution. So what you can claim is that the CRC has not improved, but you cannot say that the CRC had downgraded in many. I'm not saying in all areas, but we will look at each of the areas ultimately, because we will tear the 2020 draft constitution apart. We wish to do that, but in 1997 we did that, and eventually they made us owners of that constitution. We were helping the people to understand a document that we did not prepare, we did not own. But because we were citizens, we wanted our people to understand. Some were calling it a soldiers' constitution. They said that we were in complicity with the soldiers because of their own political agendas. This time we left it in their hands. What has happened? Who is clarifying? Who is helping the people to understand? After the fact, we are going to do it. Others may do it before us, but we're going to do it because it's our responsibility as citizens of this nation to clarify. Why? Because there can be no republic without a constitution. You cannot have a Gambia without a constitution. It defines the republic. It defines the citizenry. It defines the rights. It defines our manner of government, whether executive, whether legislature, whether the judiciary. It defines our public finance. Everything on which a nation should lie must be defined by a constitution. We must have a constitution. So what type of constitution? That is the question. You are to determine that. And therefore we must open our minds and abandon propaganda that will not lead us anywhere. So what has happened at the National Assembly is many people started to look at the details, and in our own situation, I've made it very clear in section 226. And it is only through the promulgation that you can repeal. Even though repeal is mentioned as alteration under subsection 9, but how do you repeal? Wholesale. You can repeal piecemeal, but repeal wholesale, that is the problem. So in short, that is what confronted the National Assembly, because once it moved from the angle of the CRC, now is for enactment. That is our responsibility. We cannot point accusing fingers at CRC anymore. They have done their work. Maybe they could have assisted more in terms of looking at all these issues. As a nation, we could have looked at all these issues more. But now it is the National Assembly members who were charged with the responsibility of saving the nation. And they had to use their intelligence, their capacity to examine things so that ultimately we arrive at what enables us to give us a constitution that was superior to the 1997 constitution. That's the task. But like 1996 referendum, some parties were glued to their 1970 constitution, therefore they were no longer ready to look at anything that was better. The same thing with the 1997. Some are glued with the 1997 constitution. They don't want to look at anything that is better because it is their constitution. And a constitution is not a constitution of any party or individual. This is the constitution of a nation. And we must have that national mentality. When we deal with national matters, we must be able to put our parties aside, an individual interest aside, and look at the national interest. Otherwise, the nation is doomed. So in that, what happened is very clear. In our standing orders, we had every right to be creative. Some people were saying they will take the National Assembly to court. Nobody can take the National Assembly to court when we apply our standing orders. As you can see under section 108, you cannot in any way take the National Assembly or the Speaker or anybody to court for applying the standing orders. Yes, we can pass a law and it's assented to and it becomes law. Then you can take the law and say that this law contravenes the Constitution. Yes, you can do that. But it's the law you are taking to say that it's null and void. You're not taking the National Assembly members for them to say that they have done wrong. That's not the business of anybody. That's where you have the separation of powers. That's the joy of the separation of powers. Nothing restricts us from doing our work the best way we know how. And with our standing orders, after the first reading, the second reading, it's the objects and principles that are discussed. Once you discuss the objects and principles, then you pass it to the next level. And the next level goes to the committee stage. And something like a constitution, you don't give it to just a small committee, you can have committee of the whole National Assembly. And at the committee stage, you have subject matter specialists. You can invite anybody on earth to come. This is where the nation could have benefited by getting the best legal minds to engage with the committee, the whole committee of the National Assembly, to look at it, to look at all possibilities, what we can touch and what we cannot touch. How do we put it in place and agree both executive and legislature, so that ultimately we craft a document that may not be a perfect document, but it's a document agreeable to all, and agreeable at a level where we all believe that it has risen above the 1997 Constitution. That was the task, and we could have achieved it. But the Constitution says at the second reading, 3/4 of the members must agree for it to go to the third stage. It's not to agree for it to be the Constitution of the Republic. It's to go to the third stage. And even at the third stage, you can kill it. Why can you allow something to go to the second stage when you can kill it at the third stage? To see whether your concerns will not be addressed. Or true, because at the committee stage, it's no longer the principles. You are looking at the details, clause by clause. So we would have examined it clause by clause. Can you imagine how rich that discourse would have been? For the first time in Gambian history, thinkers prepare a draft, bring it to the legislators. The legislators with subject matter specialists all sit down, and you review this clause by clause to clarify, to interpret what it means. Can you imagine the knowledge base of constitutional evolution? This will, an embodiment, the report, the minute, is an embodiment of the mind of the National Assembly. So it goes to court, and you want to know why this law came into being, everything will be documented. So that is the opportunity we had. And all of us said this is the most historic of occasions. This would have been, regardless of how Barrow rules, it's not his constitution. We would have inherited something that those who want to make it work will make it work. The institutions will be built. The mindset will be changed. And transforming the National Council for Civic Education into a genuine instrument for educating the public. No longer just something that is cosmetic. And obviously, the mindset of the Gambian, all these hullaballoos that we see, people attacking theirs, saying this and preaching there, all of us have tempered our consciousness. Where we respect each other and where we exercise their rights within a community. The need for a referendum. So if the intent clauses must be changed by a referendum, if the non-entry clause can be changed by National Assembly members, but if you take it to the president for his assent and he rejects it, he questions it, then you must go to a referendum. Then you see the trajectory of referendum is there in the Constitution. Now, to help us, if we had had this working session of looking at the draft and reach a consensus, what would have stopped for legal creativity those provisions that are not entering? You use section 102 and say that by section 102 added to section 226, we will be sending this to referendum. What could have stopped that? But it needs a collaboration between the executive and the legislature. And we could have reached a situation where at least we can do what is best now. Because the other agenda is that we must be able to come up with an amendment of section 226 that provides for could be done. How the bill could be done. It is repealing, promulgating, that touches on section 226.4, which is entering clauses. So these are the conditions of trying to even amend section 226. But with these provisions and collaboration with the two, to move the constitutional review process and then referendum. Provisions will be clearly there, telling how you promulgate, how you repeal wholesale. That was the task for us. Has been aborted. I'm engaged in this reflection today, informal reflection, before coming up with a comprehensive reflection on the way forward. What we have done, all eyes are on it. We've raised the concern to the executive and showed that, yes, we said 3 years. Well, that has been changed, that because we cannot achieve this, we cannot run a full mandate. And now party is established. Yes, now there is no coalition, there is parties ready for elections. Fine. But what has been a major promise, and that should be the epitome of whatever process exists now, call it what name, ever name, is at least the birth of a Third Republic. And that is promise. So we asked them, have you abandoned that project? And we are told that the executive will go back and reflect and come back to us. But there is a time frame. A referendum has time. Constitutional or any legal reform that affects electoral processes has time. The amendment of 2015 indicated that there should be no real major change in electoral laws 6 months before the holding of an election. So the time is extremely limited, and it is anticipated that the executive will go and reflect and then come back so that one can see whether we cannot be creative with our standing orders again to see how to reinvent the whole process and move forward. That is how matters stand at the moment. And I will come back to you in a more comprehensive manner.
Yeah, but before I will leave you, I just have a few questions. There is a chance for the draft constitution to come back to the National Assembly for second consideration.
But there is a chance in the sense that all this depends on the executive and the National Assembly. There are always loopholes you can always exploit to do things that all agree should be done. So we can
will on the side of the executive and a real national assembly, we should be able to save the day.
Honorable, you mentioned this issue of independent National Assembly members. And this has been a debate on the social media when this issue came. They said nowhere in the world it has happened, and it has never happened anywhere where you have a National Assembly consists of independent National Assembly members. And others went further to say that hadn't been that we have an independent National Assembly members, then we will not even be talking about this constitution, because by then all of them will be at the side of the incumbent as the president, and they would have voted against this constitution automatically. We will not even have whereby you will have a divergent views in the National Assembly, but it will be a National Assembly of one voice, and a National Assembly of the same voice is not a National Assembly. You must have divergent views. So what is your take on that?
Well, you see, that's what you call logic. And reality and logic cannot be equated. That's why I am saying we should not engage in a blame game. We should just know what happened. I am sure if they engage Doi and ask Doi how it conceived the whole coalition, its transition, the 3-year agenda, Doi will have its own. And I'm sure each of the other parties should be able to do so. But if you were to ask me what the Joy expectation was, is clearly stipulated. You will find it in all the documents I've just read, and you could see exactly what the trajectory was. This was the trajectory. That making President Barrow meant that he will also engage in consultation with the coalition as the head of a team. And how we selected him belonged to a party, but he had to resign from the party and engage in a contest. In the contest, I participated in that contest. I could have said, hey, this was unfair. It didn't happen this way. You can see what some of the leaders are saying, how they facilitated the election. You think we did not know? We knew. But what would we have achieved by saying this is unfair and then move out? Well, the same status quo would have remained. So what was our objective? Our objective to occur, because if change did not occur in the type of nation we would have had in terms of violence, I don't think people really know what we escaped from. That's why they are talking. Even some people who are in party was at stake during that impasse. How it would have ended, the bombardment that would have taken place in this country. Gambia would not have been a country anymore. So all of us escaped the greatest danger. And therefore the lighter danger, the smaller one, is something we should really not allow to get in our heads and start thinking this logic. What we were confronted with in 2016 and early 2017 was not about sharing positions. It was life and death. Would we survive? So in essence, what we anticipated was that the people you are going to elect will contest elections. And parties, and when they just like President Adama Barrow, when they are selected, they will resign from their parties, or if they were independent completely, they will be there so that they appear independent National Assembly members. And when they are there to change the standing orders. The standing belong to them. You see, it is where people, sometimes I don't think they really understand processes. Once we are in that National Assembly, those are the people who will prepare new standing orders to ensure that all those people will form one block. And they will go through the same trajectory of knowing that this is the coalition agenda, this is what we need to achieve. We are not even from the same party. You see us collaborating sometimes, it's unanimous. when we came to the Women's Enterprise Fund, did you see any? It's unanimous. So there are many decisions that we take unanimously, and precisely the agenda. And all of you, as I said, especially the and say, what was your perspective of the coalition? And engage another and say, what's your perspective of it? So that each party, in their most sense, to tell you exactly how they saw the coalition and how they saw the trajectory. The nation is entitled to that. Then we will not have, as far as DOI is concerned, that if we took that trajectory, we would have even honored the 3-year transition program. Because the mind would not have been there to go against it. But you see, once there is division, of course, each struggle to survive. And in the process of survival, you get wise as to how to save yourself. And essentially, that is what has happened.
Thank you, Honorable, for having us. But once again, somebody said, for him, he thinks that you are saying, going by Section 226, we could have amended and improved the current constitution rather than having a new constitution. Is that what you are saying?
You know, when we talk, as I said, you look at what is practicable. In 2017, when they brought the CRC bill, what I could see is precisely what I'm saying. But it does not mean that that is the only way, but that was the only possible way that I could see. And today, I can say, well, that possible way could have saved us a lot. So I definitely feel absolved. But notwithstanding, we don't achieve anything by saying, I said the house will burn and my properties are in the house. And I said, well, this is what I said. Well, it is burnt, it is burnt. I also lose. So that's not helping anyone to achieve anything. So it's not saying, yes, I told you. No. Now we must struggle vigorously to achieve what should be achieved, even though the domain that is taken, the trajectory taken, is different from what I thought was possible and practicable and doable.
And what will be, that's my last question, the decision taken by the National Assembly, are you disappointed or you have foreseen this?
Well, you know, we cannot pretend to be soothsayers. Everything was expected, that anything was possible. So you don't get this eventualities. Eventualities were prepared for, and that's why I had to go beyond the issue of promulgation and how and the contradiction. Well, it forces you to do more research to see, because problem solving requires for you to look at all possibilities, and therefore you see all this scenario, and that's why we are still saying that all is not lost, that maybe we can still reinvent a way, and let's hope that that way will be reinvented.
Once again, Honorable, thank you for granting us, but I think we will have more of this issue because the nation has to know what actually transpired.
Indeed.
And what is the contents of this document, because as you said earlier, there are so many misinterpretations, even in the issue of whether the National Assembly members has power to touch the Constitution. Is still now a debate, from intellectual that we consider to be intellectual, and they have followers on Facebook saying that you have no power, the National Assembly cannot even touch a dot in the Constitution.
No, well,
it has to be clear to the people.
Well, I believe now that we have definitely, because we've quoted that Section 226, 1 to 3 shows that anything that is not entrenched, the National Assembly members can actually touch, and then it goes to the president. He can reject it, and then it goes to a referendum. Anything that is entrenched, well, you take it to a referendum, and then they come back and is passed and assented to. There. But since something is a drafting process, we as National Assembly members can work with a commission, because, for example, the commission should have brought all this before, and we walk through it. So we can still work with them to do certain things. Let's bear in mind that nothing is unchangeable as long as the political will is there. So we can always see a way where we can do things that ultimately serve the national interest. Who will question us? Because the National Assembly has powers to do certain things. You go to and say that, well, this is not in line with the law, and then obviously you question it, and then they will come to a decision on those matters. But at this moment, what should exercise our mind is how this can pass the National Assembly and go to a referendum. And that's what we should start working on.
Thank you, Honorable Sallah. Others are saying the coalition has not achieved what they want, because during the coalition manifesto, what is clear there to the government citizen was an electoral reform and constitutional reform, institutional reform, and a transitional period of 3 years to lay the foundation for the Gambia. But if you look at this, within the 3 years, you could not achieve the laying of the foundation. Now the constitution that we rely on has failed. There's no electoral reform, there's no institutional reform. That means that the coalition didn't achieve anything that they have promised the Gambian people. What is your say?
Well, you know, what must be borne in mind is that this was a project that started with a government that was in place. And how do you remove that government? A government that had never been through the ballot box. That's what Gambians should bear in mind, that the mere work of removing a government that was entrenched through the ballot box and establish a peaceful transfer of power is the greatest achievement the Gambian nation could ever make after coming out of the colonial era. It's like the rebirth of a new nation. It's just like 1965. That's what was achieved in 2016. Should follow is precisely what the objectives are. And we have not attained them as we aspire to do. But then that is a starting, the beginning of a new process. It means that find out why that has not been achieved. If you look at the manifesto, you will see that even to form a government required a consultation between the president and the coalition executive. But, all that had been abandoned from the very beginning. So we've moved away from the trajectory of a coalition from the very beginning. And obviously, we are now is all have their political parties, including the president. So we are simply talking about a normal order, what we call the executive presidency. That's what exists. So there is no need for regrets. What we should simply do is to understand the reality. The reality is the reality that we have not moved on the path which we set for ourselves. We've took a different path, and that's where we are. What do we do from now onwards? That each Gambian must now know that the destiny of the Gambia is in your hands. It means that now, more than ever, we should use our brains. With the Constitution, let's go back and read every clause. If we cannot read, let's ask people to tell us what is in every clause. Let's debate about it. Move away from propaganda. Don't be moved by any individual, because that's how they take a rope and tie your neck. Don't allow anybody to just make you emotional. Follow it and find out the truth.
Thank you very much, Honorable Halifa Sallah. And we will open up this debate. I know you will have a more platform that most of the government people will listen to you to explain to us what actually transpired and what is the content of this document. Thank you, viewers. Bye from me, Keksana.